Why some Georgia's families spend $20,000 or more on probate and how to avoid it. Let's talk about that. Hi, I'm Tonya Bird with the Bird Group at Keller Williams Realty Atlanta Partners, and I work with families across Georgia who are navigating probate, especially when it comes to real estate. What I want to walk through today is not about probate in general, but the specific situations that cause probate costs to spiral out of control. Why probate costs vary so widely. Why do some Georgia families spend $20,000 or more just to go through probate, while others, they move through it far less stressed and expense? If you're dealing with a loved one's estate right now, or you're trying to plan ahead to protect your family, this is something that you need to understand. The truth about the $20,000 probate story. Here's the truth. Probate in Georgia doesn't automatically cost $20,000. But I have personally seen people spend several thousands of dollars, and sometimes even more. And when it happens, it's almost never because of one single fee. It's because of a series of decisions and delays and family dynamics that just compound over time. Why probate becomes expensive. Most families are shocked by the probate cost because they assume probate is just paperwork. They think it's a simple court process where someone just signs a few forms, transfers the house, and moves on. But in Georgia, it's a legal process overseen by the probate court, and once the court is involved, everything slows down, and every step costs money. Attorneys' fees can increase as more time is required. Court filings add up. Required notices, publications, they all have to be paid for. And the court may determine that additional protections are needed, like a bond, or that you have to go through a formal accounting of all the assets. Costs can rise quickly. No will or missing waivers. One of the biggest drivers for higher probate costs is when there's no will or the will does not waive certain requirements. In Georgia, when someone passes away without a will, the estate goes through what's called intestate probate. The process requires to identify heirs, formally notifying them, and waiting through a statutory timelines. And that adds up to time, complexity, and legal expenses when heirs don't cooperate. Another major cost driver is the lack of cooperation among heirs, even when everyone ultimately agrees on the outcome. One person refuses to sign waivers, and the state is forced into full court supervision. That means no shortcuts. The personal representative may be required to file detailed inventory, submit ongoing accounting, sometimes post a bond to protect heirs, and get permission from the court to sell the house. The hidden costs of probate bonds. Bonds are a big surprise for many families. If a bond is required, the cost is tied to the value of the estate. Sometimes you're required to do more than one bond. The higher the value of the property, the higher the bond premium. And this is not just a one-time inconvenience. It's an ongoing cost that exists solely because the court believes additional oversight is necessary. How disputes drive up costs. Costs can escalate further when disputes arise. If the heirs object to the appointment of the administrator, or they object to the sale of the home, or they object to how the proceeds are handled, the estate may be required mediation or court hearings. At that point, legal fees increase significantly as attorneys prepare for motions, attend hearings, and respond to objections. This is often where families cross into that $10,000 to $20,000 range. Not because probate in itself is designed to be expensive, but because conflict, delay, and court involvement makes it expensive. So when is probate more manageable? What doesn't get talked about enough is not every probate case in Georgia costs that much. There are situations where probate costs are far lower. That's when the will is clear, everybody has signed waivers, when the heirs cooperate, and when the requirements like bonds or formal accounting are waived. Probate can be far more efficient. I've seen straightforward cases where costs were only fractional of what people feared. The difference is planning and cooperation. And the court system is designed to protect the heirs, not punish families. But when the court senses that risk of disagreement or uncertainty, it will absolutely add layers of protection, and each layer costs time and money. why simple estates get complicated. Even a single house with no mortgage can become complicated. A probate case if the right steps aren't taken early. Waiting too long creates problems. One of the biggest mistakes families make is waiting too long to get guidance. They try to figure out things on their own. They assume they can clean out the house or sell or distribute property before they have legal authority to. Although I'll say if you're doing real estate in Georgia and you're trying to sell the house without legal authority to do so, the closing attorney is going to catch that. But that often creates more problems than fewer. The emotional side of probate. Another common issue is understanding how emotional probate can be. You're grieving your loved one's passing. Families who generally get along all of a sudden can struggle with grief, money, and the memories are all colliding together. Those emotional dynamics are often what triggers objections and delays and additional legal requirements. And I don't care who you are, if you're an administrator or an executor, this probate thing isn't for the faint of heart. How families avoid most expensive outcomes. So how do families avoid ending up in a $20,000 probate situation? Well, it starts with understanding how probate outcomes are influenced by planning, documentation, and cooperation. Having a proper will prepared matters. Making sure that the deeds are structured correctly. If you take a deed in Georgia certain ways, you can avoid probate altogether. Communicating expectations ahead of time also matters. So what do you do if you're already in probate? For families who are already in probate, the best thing you can do is get professional guidance early, especially if real estate is involved. Selling a home through probate can often help cover estate expenses, but it must be done correctly and in the right time in the process. Planning ahead versus avoiding probate. If you're planning ahead, remember this, probate avoidance and probate efficiency aren't the same thing. Not everyone avoids probate entirely, but many families can avoid the most expensive version of it with the correct preparation. So if you need guidance on what that preparation is, let me get you in contact with a Georgia probate attorney or with an estate planning attorney that can help. If you're dealing with probate in Georgia and want to help understand your options in navigating the real estate side of it, feel free to reach out. We work alongside with attorneys and families to help reduce the stress, protect the value, and keep things moving forward. Be sure to make sure that you hire an agent who understands probate. We have to go out and learn extra education to be probate specialists, and not all agents understand it. So if you found this video to be helpful, consider subscribing to the channel. We share weekly content focused on Georgia, probate, real estate, and planning strategies designed to avoid it, to protect families, and to preserve their wealth, their real estate wealth, and their legacy. You may also want to watch the next video where I might explain another probate problem that comes up that catches people off guard. At any rate, thank you for watching, and I'll see y'all later. Bye.